Yeah. Okay, this is 4 voices will be at 2:10, and one more time we will identify. I am Mr. Cole for Defense 2.
I am the court.
I am Mr. Canat for Defense 1.
I am attorney for the plaintiff, Mr. Graham.
And it's the court for the record. Mr. Canat, since we're making a record for this case, why do you say the vehicle, the decedent's vehicle, is so critical? Why are you making that statement?
I'm making that statement, Your Honor, because it appears to us that the evidence will show that in ample time, the driver of that machine would have seen this tractor in plenty of time to either stop or to make other evasive maneuver.
Is the whatever in the hope of the whatever the vehicle may have shown is going to preclude any evidence of any liability on Mr. Cox, the defendant, as to him being a proximate cause of this accident? I'm using the word approximate cause because keeping in mind there can be multiple proximate causes.
I understand that, Your Honor, but in order for Mr. Cox to be criminally responsible for this accident, there should be a showing that he violated some law and that violation was a proximate cause of the accident.
A proximate cause.
That's right.
If Mr. Cox was a proximate cause of this accident and the decedent driver of the vehicle was a proximate cause of the accident, do you think that would be a defense of this case or even relevant?
No, but we expect the automobile to provide information upon which our expert will be able to testify that the traffic violations, if there are established, or the infractions or misdemeanors, whichever they happen to be, were not a proximate cause of the accident of the collision. We don't know at the present time, and we can't tell from the evidence available whether the brakes were working properly, whether the lights were on the automobile. We expect to be able to show the normal lighting of an automobile traveling at and within the speed limit would have illuminated this tractor with ample stopping distance so that the conclusion could easily be reached that whether there was an orange delta or a red tail light on the tractor had nothing to do, that the proximate cause of the accident could be that excessive speed on the part of the decedent or the fact that the brakes were not operative or that he was driving without headlights.
If the statute requires the driver of any tractor, that driver of that tractor must have exhibited a delta as designated by statute of the size, the dimensions, the color, and the reflection of it, and the statute requires that the driver of a tractor who is driving on a roadway must exhibit that reflecting device, plus if the statute is that the driver of that tractor must drive on a certain portion of the roadway, is it not such that that statute sets up a duty of that tractor to all other drivers on the roadway, regardless of the day or night or the weather condition?
That's true.
And if that duty is abrogated and not followed, then there's a breach of that duty. If there's a breach of that duty, then you know you need to, that is in because the proximate cause of an accident.
That's correct, Your Honor, and that's the critical issue in this case.
Well, may or maybe not. Obviously, if the statute says you are driving a vehicle at nighttime, you must have your headlights on. And if you drive a vehicle, the brakes must be adequate to stop the vehicle. And if one has no headlights on at the nighttime and has zero brakes on the vehicle, that duty is breached. And if you have the driver of a vehicle with no headlights and no brakes who collides with the tractor with no reflector and is driving in the wrong part of the roadway, are they not equally negligent in their act? Or if you have the driver of the tractor with no reflectors driving in the wrong area and the driver of the vehicle with headlights and with brakes who goes down the roadway and still crashes into that tractor, is there not some negligence on both parts?
As described by Your Honor, that's correct.
May I respond to that, Your Honor?
I'm not going to make a decision on it.
May I respond to that question?
Certainly.
Your Honor, I think that you've got to consider what's the reason for having that triangle and the red light on the back of the tractor. Let's assume in your hypothetical situation, the driver of the automobile has no headlights and no brakes and a mile ahead of him. He sees a tractor with no triangle and no red light, and he continues to drive that vehicle with no brakes and no lights, and he's going 90 miles an hour, and he still sees the tractor.
And he piles right into it.
And he still sees the tractor. If you can't, you've got to, I think, look at the reason for that red light and the delta. Obviously, it's to make yourself visible. So if you are, in fact, visible, you've really satisfied the same reason for the law. So the fact that the delta isn't there has nothing to do with the accident, and the fact that the red light is not on the back of the tractor has nothing whatsoever to do with the accident. And so the driver of the tractor is not in any way a proximate cause of the accident.
Your Honor, may I respond to that?
No, I'm not going to make a determination whether there's negligence or non-negligence for not having any of that equipment on the tractor. It's not my province. My province is, though, to wonder whether there is, well, maybe it is my province. Respond.
Your Honor, I think Mr. Cole hit upon the critical thing that I believe he really requests, and that's a resurrection of Manuel Acuna. His hypothesis of the lights were on, and that I should say the lights were off, and he still saw the tractor down there without the delta, and he still ran into it, and then that's a critical factor, and now he wants to cross-examine someone who's dead. That's the real critical thing, that perhaps the most critical thing to the defense, and that obviously they could not obtain. The point being is that they're grasping at straws.
I don't know whether they're grasping at straws or not. Well, Mr. Graham, in your argument as to whether we're going to stack up automobiles in the city of Los Angeles and the city of San Francisco as an argument as to whether the automobile should be preserved, I don't think that that would be a valid argument in determining whether defendant's going to be deprived of a fair trial or not.
That's only illustrative of what
Could happen.
could happen, and what defense counsel is really asking the law enforcement agencies to be responsible for.
If that's what the law requires, then I guess that's the way it's going to have to be. I don't think we can take that into consideration. I think the public policy is that regard would be certainly have to yield to the right of the defendant to a fair trial.
But what's the requirement? The burden upon law enforcement in every accident situation where there's a possibility of a prosecution. That's really the ultimate question is what defense counsel is really saying is that, gee, Highway Patrol, you didn't do the right thing. You should have put a hold on everything, that tractor, the other truck involved, the actual car involved in freezing. And here we are. It's 7 months down the line since the accident occurred, and we've still got it.
What I'm really saying is the inconvenience of the utilization of space and property is certainly far outweighed by the right of the defendant to a fair trial. I think the issue is a legal issue and not to be determined as to what effect it's going to be to stack up automobiles or trains or Empire State Buildings. That's what I think is not going to answer the question. I'm going to read in Jesus B before I make a decision. Besides, I think Ms. Reporter's fingers need to relax. Why don't we start again at 1 o'clock, which is about 40 minutes from now? 1 o'clock. Let me read the case and give the reporter some time to rest. Mr. Canant going to be here, Mr. Cole?
No, Your Honor.
Maybe to some other judges looking at this thing from the outside and inside, rather than being involved, and I could see some very complicated problems with this motion. I'm satisfied the motion to produce is denied. The people, I feel, do not have a duty to preserve the automobile at its first instance, and therefore I am not going to order it be produced. The motion is to dismiss is denied. I have a problem, however, and I take it that whatever my decision is, this case is going to be appealed. Is that correct?
Apparently, Your Honor.
Well, whatever. And let me do this. Maybe I don't have jurisdiction to do it, but I'm going to put it on the record. Since the Highway Patrol conducted, in essence, an experiment in the investigation in this case, they examined the brake system on the destroyed vehicle, and they themselves then ran a skid test. As a result, I think that once the Highway Patrol did the examination of the brake system, and then the subsequent skid test indicates there must have been some need for evidence in that regard, and they should have preserved the braking system of the vehicle.
Let's skip to page 54, please, line 1, and that's the court.
Now, do you want to set this for a date of trial, or do you want to set it in a couple of weeks for further pre-trial, or do you want to do, what do you want to do, Mr. Cole?
Why don't we set it for pre-trial, Your Honor? Yeah, I think pre-trial would be the best thing, Your Honor. And then if there's an order from the Superior Court directing this court to take no action, I would assume I wouldn't appear at the pre-trial.
Yeah, if you get a writ or if you file a, whatever you need to do, certainly then we could stay whatever proceedings are in this court.
May we suggest 4 weeks away, Your Honor?
Time waived?
Yes, Your Honor.
Time waived?
Mr. Cox is present to orally waive that time also, Your Honor. As a matter of fact, has the bench warrant been stayed forever and ever?
Let's do that right now. Permanently stay the bench warrant. I don't need Mr. Cox's personal waiver of time. I need yours.
I waive time.
But I need his personal waiver of jury trial.
I beg your pardon?
If Mr. Cox, when the day of trial is up, in order to vacate and waive the jury, I need Mr. Cox personally to waive jury along with your concurrence. But you can waive time over Mr. Cox's objection.
You mean waive time for the jury trial?
Right, waive time for the jury trial.
Not waive the jury trial.
Once I give a date for jury trial, I need his verbal statement that he concurs or makes the motion for the setting aside the jury and doing it again. That's the way I look at it, permanent stay of the bench warrant.
Thank you, Your Honor.
Mr. Cox, he must have been on his own recognizance, if I recall, way back.
Yes, Your Honor.
Sign a new promise to appear, Mr. Cox, and you'll be released on your own recognizance again. Since my recollection is I vacated your release. All right. 4 weeks satisfactory with the people?
Yes, Your Honor.
Are you going to be here one of those days in June, Mr. Cole, the 12th? The June 19th, he's going to be here. June 19th, okay?
June 19 at 10:30.
Fine.
Excellent. I think Tuesday will be an appropriate day.
I think there will probably be a stay somewhere along the line, I would hope.
I hope so too.
June 19th at 10:30, unless the Superior Court Appellate Department just totally concurs in my decision. All right, Mr. Cox, sign that promise and appear. You're ordered back to court June 19th, 2009 at 10:30,
Your Honor,
unless notified by your attorney otherwise.
obviously it would be important to have a record of these proceedings transcribed.
Do you need them transcribed for the writ? For the appeal, I know you're going to need them transcribed.
I probably don't need it to make the application for the writ, but certainly the court's going to want it to make a determination on the writ.
Why don't we wait until that happens? Because what I want to do is go through this transcript that was done from the tape, and if necessary, I'll certify it because this was done from a tape recording. Now we have a certified court reporter. She will certify it. So why don't we wait until that happens? But if necessary, I'll make the order.
Thank you, Your Honor. Okay, we skipped that over because that was the court for like 3 pages. That's what happens.
I enjoy reading.
Okay, this next one is, we get to share. I haven't done that for a long time. You guys remember how to share?
No.
Share nicely. You can put. Okay, so we have Mr. Rasmussen for the plaintiff, Mr. Rodriguez for defense. And I am the witness.
I am the court.
I am Mr. Rasmussen for defense.
I guess I'm.
Oh, wait a minute.
It's on your front page. Rasmussen is plaintiff, Rodriguez is defense. So who are you, plaintiff?
Okay, are you plaintiff?
Yeah.
Yeah, I'm the
Then you're
plaintiff.
Rasmussen. Okay, I am Mr. Rodriguez for defense.
I am attorney for the plaintiff, Mr. Rasmussen.
Okay. And we're going to start with the court. We're reading in 15s, and this also is a 210.
And it's the court for the record. Mr. Rasmussen, you may call your first witness.
Your Honor, the people will call Rodolfo Moreno to the stand.
If you'll please raise your right hand, facing the clerk to be sworn.
I do.
Please state your name and spell your name for the record.
Rodolfo Marina Rezo, Rodolfo, Moreno.
Thank you.
Let me spell my name, please, Your Honor. Razo.
Thank you.
Good morning. Can you tell me where you were on December 25th, 2006?
On Christmas, I was at the address of 1608, 6008, interpreter's correction. 608 Moray Avenue in Laura's house. In the morning when we got up, we started watching television.
Okay. At the Moray Avenue address, who lives there in December?
Right up until now, Laura lives there. Only Laura. I went to live with her in May, at the end of May.
Okay. But you were over her house on Christmas morning?
Yes, because we were spending time with the family.
Okay. And in the morning, who all was in the house?
Laura, the boy, Esteban, Laura's sister, and I. And that was all.
You said Esteban was there?
Yes, he was there.
Your Honor, may I approach?
Yes.
Showing you what has been marked as People's Exhibit number 2. Do you recognize that?
The photo, yes.
Yes, and who is that?
That's Esteban.
Do you know his date of birth?
Of the boy? No.
No, okay. And he was home on Christmas morning?
Yes.
Yes or no? Did you see something strange that morning?
Yes, when the boy came close to me.
Okay, what time was it when this happened?
It happened twice. The first time around at 7, more or less, on a chair. He laid back on the chair doing things like jumping on the chair. And I said to him, Esteban, we don't do that. And he came and he hugged me. And I told him that was okay, nothing was going to happen. And then his mom called us so that we would go have breakfast.
Let me stop you right there. You said Esteban, you saw him jumping on the chair. Can you describe that?
One moment.
Yes, he was jumping on the part where you lean back on the chair.
Okay, and just jumping up and down?
No, jumping like forward, doing things that people shouldn't do.
Okay, what part of Esteban's body was touching this chair?
His masculine part.
His crotch area where his penis is?
Yes,
And was he rubbing it against the chair?
like he had a sensation, like he was jumping on it, something that wasn't normal for a child of that age, in my opinion.
And you told him to stop?
Yes, I told him that we don't do those things. That's not good. And then he came and he hugged me.
Okay, and you say this happened about 7 a.m. on Christmas morning?
The first time.
Okay. Were there Christmas gifts in the house?
Yes, around the tree, there were many gifts.
Okay, have those been opened yet?
Some of them were, but there were many that were not open.
And was anyone else in the room with you and Esteban?
Well, that happened in the living room.
Okay. Was there anyone else in the living room with you and Esteban?
No, his mother was in the kitchen making lunch and I was watching television.
And then after you said Esteban came over and hugged you, that you said then you were called to go eat.
Yes, to have breakfast.
Okay, to have breakfast. And you said that was the second time.
After we had breakfast, I went back to the chair. I was watching television.
And who else was in the living room?
His mother was there picking up the things in the living room. She was cleaning.
And what happened?
His mom was cleaning everything, the floor. After lunch, like 8:30 or 9, the boy was playing. He came and he got on top of me. I was laying back and he got on top of my right leg and he did the same thing that I had seen him doing on the chair. He did it to me.
Can you describe that again?
I was laying back watching television in this chair and he was playing. He got close and he did like when you have relations, he was jumping. And then I started thinking that that's not right for a little boy. So I asked him where he had seen that or who had shown him that because we didn't see that here in the house. Then he hugged me and I said, "Who did that to you? Who does that or who showed you that?" And he hugged me and he said he was afraid and he didn't want to say. And then he said his uncle. I said, "Which uncle?" And he said, "Sabina." Then what I did was I went.
Let me stop you right there. So the second time, and you said it occurred, and correct me if I'm wrong, around 8:30 or 9.
Yes,
And what he did was the things that you have described that he was doing to the chair, rubbing his crotch and his penis area. He came over to you and was doing that to your right leg.
yes,
Okay. And you told him to stop.
yes. I said, "We don't do that."
Okay. Had you ever seen Esteban do that before, December 25th, 2006?
Just the 2 weeks before I noticed the boy, when we went to pick him up there in Lodi with his dad, I saw that the boy was sad. I noticed he was kind of sad. He didn't say anything, but we just noticed he was that way. But I just saw that there was something strange when we handed him over to his uncle Savina. The last 2 weeks, he turned the boy over to us, those 2 weeks before Christmas. And I saw then that at that time, the boy seemed like he was someone else, that something was happening to him. But it never occurred to us that something like that could be happening until this.
Let me stop you right there. You had never seen him do anything, rubbing his crotch against anything before Christmas, correct?
No, never.
Okay. And when did you first meet Esteban? Were you first introduced to Esteban Doe?
I met Esteban the beginning of last year when I started to go out with his mom, but I didn't have much to do with him. Just when we would go out to eat, we would invite him to go out to eat with us. That's all. Because I wouldn't see him too much because I lived in my apartment, she lived in her house. And so I started having contact with him in after July, we started to go out to eat. We went to the fair, but not have a lot of contact with him because we didn't live together. Just every once in a while when I would see her. And since he was with his father on the weekends, I didn't have contact with him and I didn't see him either.
Okay. And now back to Christmas Day, when the second time when Esteban is doing this and you asked him, who told you how to do those things? And after that, what did you do after he told you?
At that moment, he hugged me and he didn't want me to tell his mom. He said, "Don't say anything." So what I did was I went to his mom, I talked to her, and when I told her what Esteban was doing to me and the name that the child had said to me, she was very surprised. And she was very surprised and she said, "Sometimes the boy says things that aren't so." And I told her this is very serious. I told her that this was very serious, that maybe the child would lie to her about not having done his homework, not having taken a bath, things like that, and that she should talk to him because he had said that his Uncle Savino was touching him. So then she grabbed him and she went into the room
Okay.
with the boy, and then she came out surprised by what was happening. And the boy came back again and hugged me, and he said he was afraid of his Uncle Savino.
Let me stop you right there, okay? When you dropped Esteban off, you went with Laura sometimes?
No, because his father picked him up on Friday, sometimes on Thursday, but almost always on Friday. Sometimes he would send somebody to pick him up on Friday. But since I started going out more frequently with Laura, I accompanied her every Sunday at 6 in the afternoon to pick him up.
Where did you pick him up? What city did you go to?
Sometimes his father would call us and say that we should pick him up in Lodi at the church, or more recently, we picked him up in Stockton. But during this time, when this happened, we picked him up in Lodi.
Okay, and what was Esteban's father's house?
We would pick him up in front of Esteban's father's house, in the church is right next to the house. We would pick him up in front of the church.
Okay, and that's in the city of Lodi?
Yes.
Okay, Mr. Marino, do you know this man here? Have you ever met him?
I met him when the police arrested him.
Okay, when you say met, you saw him?
I saw him from a distance from the car when they were arresting him. I imagine it's him.
Okay, so you don't know him personally?
No, I just saw him when they were arresting him.
Okay, nothing further at this time, Your Honor.
Okay, cross-examination?
Yes. Is it Mr. Marino? Sorry, your name is Mr. Marino, is that right?
My last name.
Thank you. I wasn't sure if you used Rezo or Marino. I'm going back to December 25th of 2006. You said you saw Esteban jumping on the chair.
Yes.
Did you notice if his penis was erect?
No.
How about the second time that this was happening did you notice if his penis was erect?
No, because he was just making movements, that's all.
Was he saying anything when he was making these movements?
Just like it was making a sensation for him, and he would make his face like a happy face, like some sensation.
After he hugged you the second time and he said he was sorry and he asked you not to tell his mother, was he crying?
He just said that he was afraid, and he was afraid of Savino.
He specifically mentioned Savino's name the first time. Second time he hugged you.
The name of Savino, he mentioned it.
Did he mention that name before or after you questioned him? Who taught him what he was doing?
When I asked him who had taught him that, who had done that, or where he had seen that, he said he was afraid.
Afraid of what?
I don't know. He just said that Savino was bad, and he hugged me.
Did you ask him for any more details?
No, because as soon as he said that, he said the name of Savino was doing that to him. I talked to his mother.
His mother initially didn't believe you, did she?
She didn't believe the child was doing that, or she didn't believe that what he was saying, that Savino did that.
Well, didn't you say that mother said that the child sometimes doesn't tell the truth?
Well, that the boy sometimes lied. And I told her he might lie about whether or not he did his homework, whether or not he took a bath, whether or not he got into some trouble. But something like this, that is so very serious, the child would not lie.
You're supposing this though, aren't you?
I'm sorry, counsel?
You're supposing this, aren't you? You suppose that the child lies about his homework?
But every child, they lie about their homework. They did their homework, they didn't take a bath, they took a bath, or they got into some trouble, but something that happens to them physically, they're not going to lie.
Has Esteban Jr. ever lied to you?
No, he's never lied, as I said. He might lie about if he played PlayStation or he didn't do his homework, but up until now, he hasn't lied. And he said that this happened with Savino.
Now, were you with Laura Ramirez on December 17th when she picked up Esteban Jr.?
Yes. Recently, up until now, I have gone with her to pick up the boy.
Did you get out of the car?
No, I always stay at the steering wheel. The one who gets out is her because his father walks him towards her.
Did his father walk him to the car that day?
The last 2 weeks before the 25th of December, his father did not give him over to us. Savino did. The first time he went up to the door of the house and he walked him towards us, something his father would never do. Okay, we're gonna stop there and move on. I would really challenge you guys, if you want to hold yourselves accountable. When you sit in on the take-in here, take it, transcribe it, and you can access the video and grade it against the video. Just replay the video and grade it yourself, and then look at your notes to see how you hit. Like I said, there just really is no replacement for that that accountability and the consistency of doing that transcription over and over and over. Okay, this will have some warm up and then it will be a tape. We have PV sheet. Okay, so we have Mr. Houston for the plaintiff, Mr. Canty for defense, court, and a witness. Looks like we have about 4.5 minutes of warm up, and then we'll do a 12-minute tape. I am the witness.
I am the court.
I am attorney for the defense, Mr. Canty.
I am attorney for the plaintiff, Mr. Houston.
And let's keep it in 14s, the warm up, and make sure it tells us where to stop here. It does. On page 91, it tells us where to stop. So we'll start with a question by Mr. Houston, 14s.
And it's Mr. Houston questioning for the record. At some point, had the defendant stated he was hungry?
Sometime earlier, he believed he hadn't eaten since 10 a.m. earlier.
Did he request food to get fed?
I don't think he requested it. He was just mentioning that he hadn't eaten anything since 10 a.m.
So was it someone's idea to get McDonald's or?
Detective Sergeant Borges decided to get food for everybody, and he included Mr. Mayor.
Okay, I don't have anything further.
If Mr. Mayor had told you that he wanted to go get food himself, would you have allowed him to?
I would have again contacted Detective Vieira and relayed that request to him.
Well, do you remember once again testifying at the preliminary hearing and me asking the question, had Mr. Mayor asked you to go to McDonald's at the time he was brought? Do you remember what your answer was?
I believe my answer was probably no. I wouldn't have allowed him to.
In fact, just so we're clear, I guess we should.
You're referring to the prelim transcript for purposes of impeachment?
That is correct. Well, the court can take judicial notice what's in the transcript.
Just refer me to the page and line number and we'll put that into the record.
Well, I'll go back. I don't think I referenced it to the first time the court's question was if he was free to leave. The detective said he would call Detective Vieira on page 72 of the preliminary hearing transcript, lines 27 and 28. Detective Yutsuya was asked if the defendant could leave, and his answer was no, and it's in the cross-examination, so I have to get it there. It looks like page 83 was the discussion of McDonald's, in which the detective, on lines 14 through 18, at which time Officer Yutsuya indicated there was no discussion about Mr. Mayor going to get lunch himself. That's the only discussion there. There was also, I think, on the next page, sorry, on page 85, just as far as impeachment, I don't think I listed the page numbers. I think I just asked him what the testimony was at the preliminary hearing, but
for impeachment purposes, you only need to refer to the page and line number and read the question and answer.
Okay, page 85, line 8, the question was asked, did Mr. Mayor ever answer the phone? And the answer was, I do not believe so. I think that was in contradiction to some of the things Detective Yutsuya said earlier. Had Mr. Mayor got up to go to McDonald's? I'm asking a question at this point. And you're not able to get a hold of Detective Vieira. Would you have allowed him to leave the house?
No.
I have nothing further.
Did you ever communicate to or tell the defendant specifically you can't leave the house?
No, I did not.
Did he ever ask you to leave the house to go get some food?
No, he did not.
Nothing further.
Okay. Do you have further tapes?
Yes, I do, Your Honor. There's one full tape, side A and side B, before we get to the final tape. That I think the final tape is going to be, there's only one side, side A, that's going to be our last tape in regards to Detective Yutsuya.
Go ahead and lay the foundation.
Your Honor, if I may, does the court have a transcript? I don't know. I think it would have been probably the last on the top. It says tape 3, side A, and tape 3, side B.
No.
Okay, does the court have 37A?
Yes.
But the court does not have 37B.
We haven't done 37B. 37A is tape 2, side B.
And 38 would be tape 3, side A.
The clerk marked A tape 37 already.
That should be tape 2, side B.
Well, that's in the tape I have.
What is the tape?
This is tape 3.
Okay.
Are the stickers on the cases?
Going chronologically, what you have marked so far is 32. It's the tape of the first interview by Vieira. 32A is the transcript. Then next chronologically, you have 34, which is tape 1. 34A is the transcript of tape 1, side A. Then 34B is the transcript of tape 1, side B. And going to 36 is tape number 2. 36A is the transcript of tape number 2, side A. Going to exhibit 37. 37 is tape, simply as a tape unidentified. 37A is tape number 2, side B, transcript.
I think that's where the confusion has come.
There is no tape 37, but it's already marked 36.
What's 37A?
Transcript?
37A is transcript of tape 2, side B.
That really should be 36B in keeping with the,
But he's already marked them, and we've already referred to them for purposes of the record. And you will displease the appellate court if you change those exhibits at this stage after the witnesses have already been referring to them.
I understand.
Boy, aren't we glad that was just in the warm-up? If I had more time, we'd do that a few times. This does very shortly get into some basic question and answer, so don't be discouraged by that warm-up. It was tough. Okay, so I'm going to pause the recording and turn it back on, and then we'll be doing a 12-minute 200.